Hello and welcome to the second in a series of webinars that I am going to be hosting over the next few months, which will cover a variety of topics concerning contentious probate claims. For those of you who don't know me, my name is Ali Toe and I'm one of the senior associates in the dispute resolution group here at Boyce Turner. I will be hosting today's webinar. A little housekeeping before we start. This is a live webinar, so please feel free to post any questions you may have as we go along through the chat panel. This webinar may raise a number of questions, so please bear with me. I will try and answer your questions at the end of the webinar, but for any of those that I'm unable to respond to, I will endeavour to get back to you separately. I may not be able to answer specific questions on air, as I may need to understand more about the context of the matter and the question. However, if you do need to talk to me about a specific matter, please contact me directly and I will come back to you separately. Although live, today's webinar is in listen-only mode. However, as I say, you can send me any questions or comments through the chat panel and I will do my best to answer as many of them as I can at the end of the webinar. Contentious probate claims cover a wide variety of topics, including lack of testamentary capacity and wanton knowledge of approval of wills, undue influence and forgery, rectification of wills, lost wills and deathbed gifts, proprietory estoppel claims, Inheritance Act claims, and the removal of executors or administrators. Last month, we looked at the question of lack of testamentary capacity and wanton knowledge of approval of wills. Today, we're going to look at invalidity of wills due to undue influence and forgery of wills. So, undue influence. To establish undue influence sufficient to invalidate a will, it must be shown that the making of the will was not a free and voluntary action, i.e. that there was coercion. In the case of preparation and execution of wills, it's only when the will of the person who becomes the testator is coerced into doing that which he or she does not desire to do that it is undue influence. In transactions other than the execution of wills, undue influence may be presumed in certain defined relationships because of the nature of the relationship between the parties, namely trust and confidence. These defined relationships include trustees and beneficiaries, principals and agents, solicitors and clients, and parents and children. However, presumed undue influence does not apply in the case of execution of wills. There has to be actual undue influence. Claims for undue influence are rarely successful. This is because they are very difficult to prove. Evidence in support of any claim for undue influence must be very strong and independent. It should be remembered that persuasion does not necessarily amount to undue influence, as long as it does not overpower the testator's will to that of the person doing the persuading. A will will not be admitted into probate if its execution is proved to have been procured by the actual undue influence of a person over the testator, so that the testator was induced to make a will that they would not otherwise have done. It's not enough to infer that a person made appeals to the testator to make provision for them. There must be a distinction between legitimate persuasion and illegitimate coercion. There are many forms of coercion. Evidence of actual or threatened violence would be viewed in the gravest light, but more subtle means may be employed. For example, pressure on a terminally ill patient in the final stage of life is likely to be minimally beneficial to person, may be prepared to be imposed on merely to have peace and quiet. Nonetheless, actual undue influence will not be found unless it can be proved that, should the testator have been able to, they would have acknowledged that they did not wish to do that which they did, but felt compelled to do so. If it is proved that only part of a will was procured by undue influence, where that part of the will is distinct and severable, It may be severed and the remainder of the will admitted into probate. Whilst the burden of proving a will is on the person propounding the will, i.e. the person seeking to have it admitted into probate, this burden will generally be discharged by showing that the will was duly executed and that the testator had testamentary capacity to make the will. The person alleging undue influence would then have to prove that the person in question was in a position to influence the testator, the person in question did influence the testator, the influence was undue, the influence related to the disputed will or some part of it, and it was by means of the exercise of that undue influence that the disputed will came to be made. Additionally, as I've said, strong independent evidence must be provided. This may come from acquaintances and neighbours who knew the testator well, a medical practitioner, carers or social workers, a family member, albeit with the proviso that their evidence may be prejudiced, or perhaps legal advisors who dealt with the business, not just wills, of the testator. As I mentioned, cases of undue influence are rare, but there have been 2 recent interesting reported cases. So let's have a look at them now. Firstly, Schroeder and Schroeder, a case which was heard in 2013. Mrs. Schroeder was 98 years old and she died in 2008. By her last will dated 12 April 2006, she made some specific legacies to her grandchildren and other people, left her house, which was the main asset in her estate, to her son Nick, and the residuary of her estate in equal shares to Nick and her other son Bill. It was common ground between the parties that the residuary estate had little, if no, value. By her previous will dated 1 October 1990, Mrs. Schroeder's residuary estate went to Nick and Bill equally and included the house. Initially, Bill instructed his mother's former solicitors to administer the estate according to her 1990 will. This was about 6 months after his mother's death, and it was only at that stage that Nick informed his brother and the former solicitors of the 2006 will. Nick said he'd only discovered the new will about a month after his mother's death, but had further delayed telling Bill about it because he had a thing about wills. This evidence subsequently proved not to be true. Bill brought a claim in relation to the April 2006 will, alleging, amongst other things, that his mother had been unduly influenced by Nick when executing the will. In 2005, Nick had moved in with his mother along with one of his sons after his mother had suffered a nasty fall. He continued to reside at his mother's house at the date of her death. Nick contended that his mother's decision to change her will reflected the fact that he'd been caring for her for many years, to compensate for the fact that Bill had received substantially more in money's worth from both their parents during their lives, and because he had sold his own house to fund renovation works that needed to be carried out at his mother's house to make the house fit for her to live in following her fall. This was denied by Bill. He contended that he duly influenced his mother as regards the execution of the April 2006 will for his own financial means, and also to fuel his open hatred of his brother. Having heard evidence from both Nick and Bill, together with various other witnesses, the court found that Nick had not sold his house to fund any renovation at his mother's house. The works which were carried out at the house involved improvement to the kitchen and not the entire house as alleged by Nick. Furthermore, Nick's house was being sold by his trustee in bankruptcy, following Nick's bankruptcy in 2002. The sale of his house therefore had nothing to do with his moving into his mother's property to care for her. The court also heard that Mrs. Schroeder's house backed onto an extensive yard and storage area, which was owned and occupied by Bill for the purposes of carrying out his vehicle repairs business. Access to the yard was via a track at the side of the house. Nick gave evidence to the court that his mother believed the existence of the yard devalued her property, and that her gifting the house to Nick was also intended in part to compensate him for this, and also to ensure that he retained a roof over his head after her death. Mr. Justice Mann, giving the leading judgment, said he found that Nick was very capable of being a dominant character and having a short fuse. As such, his physical presence and personality around the house would be likely to produce a significant degree of subservience in an anxious, dependent, and increasingly frail elderly lady in his care. He stressed he was in no way finding that abuse had occurred, but that he considered it entirely plausible Nick would get cross with his mother from time to time, and that she would be anxious about him and anxious to please. As to the making of the 2006 will, the court heard that Nick made all the arrangements for this. He contacted the solicitors, but he did not contact the solicitors who had dealt with the preparation and execution of his mother's previous will, and who had also dealt with various conveyancing transactions over the years. Nick told the court that this was because his mother had already spoken to them and been told that they did not do home visits. However, the court also heard evidence from the solicitor who had prepared the previous will, and it was not surprising to learn that her firm did do home visits. Nick's evidence was that other than arranging the appointment for his mother to see the solicitor, he had had no involvement with the preparation or execution of the new will. This proved not to be the case when the solicitor produced a draft of his mother's will on which Nick had written various endorsements and amendments in his own handwriting. Although the amendments were relatively minor in nature, it nevertheless threw further doubt on Nick's credibility, as his evidence to the court was that he had no knowledge of the contents of the 2006 will and had not until after his mother's death. The court held that in order to make the amendments that he did to the draft will, he must have read the contents thereof, and his suggestion in his evidence that he did not have any knowledge of the will's contents was therefore not true. Having heard all the evidence, Mr. Justice Mann concluded that there was sufficient evidence to infer undue influence. He considered that Nick was instrumental in sowing in his mother's mind the desirability of his having the house, and doing so took advantage of her vulnerability. He said it was not possible to determine any more than that the precise form of the pressure or the occasion or occasions, but that it was not necessary for him to do so. He was satisfied that the making of the 2006 will resulted from some form of undue influence. Accordingly, he pronounced against the 2006 will and instead propounded the 1990 will into probate. And then in Chin and Chin in 2019, one of Mrs. Chin's children, Ivy, brought proceedings alleging Mrs. Chin's last will was procured by the undue influence of her father and or her brother. Mrs. Chin died in November 2015. She was survived by her husband, George, and her 6 children at the time. Mrs. Chin, who had only basic command of the English language, executed 3 wills, the first in 1994, the second in September 2009, and the last in February 2011. In the proceedings, Ivy also claimed that a transfer her mother had effected of her share in a property in Southend to Samuel, Winston's son, was procured by the undue influence of her father and her brother. Mr. and Mrs. Chin moved to the UK in early 1965. They bought a shop in Great Wakering, from where they operated a takeaway business. Mrs. Chin did all the cooking and Mr. Chin served. As their children grew, they all helped out in the shop after school and at weekends. Over the following years, Mr. and Mrs. Chin bought various properties in Hong Kong and the UK, including 2 properties in Southend. It was not in dispute in the proceedings that Mr. Chin made it clear to the family that in accordance with Chinese tradition, as each daughter married, they would leave the family and become part of their husband's family. But when Winston married, as the only son, he would remain part of the Chin family and carry on the family name. It was also made clear that he was expected to carry on the takeaway business and would inherit family assets. However, by 2009, Mrs. Chin was openly indicating to the family that her intention was to leave her share in one of the Southend properties to her 5 daughters. Because of her love for them and in recognition of their having worked in the takeaway business when younger. In September 2009, Mrs. Chin then executed her will, in which she expressed her desire for her share in one of the Southend properties to pass to her daughters. She then executed her 3rd and final will in 2011. By that will, she bequeathed all her estate to Winston. In evidence, both Winston and his father said that Mrs. Chin had changed her mind. Conversely, the evidence given by the daughters was very different. They said that the subject of Mrs. Chin leaving property to them had been a bone of contention between their parents for many years. They recounted many examples of arguments between their parents, with their father aggressively displaying his disapproval over their mother's wishes. It was against this historical background that the daughters alleged undue influence. In addition, the court heard evidence that Winston made all the arrangements and paid for the execution of the 2011 will, which was prepared in English with no Chinese translation of it, and shortly after Winston had learnt of the contents of the 2009 will. Neither Winston nor his father gave any evidence as to why Mrs. Chin wished to change her will. The judge found that Mr. Chin did begin to put pressure on his wife to leave her estate to the male line following the execution of her 2009 will and following her deteriorating health as a result of a stroke that she had suffered earlier in 2009. The judge considered that the resilience which Mrs. Chin had shown in 2009 was by the end of 2010 or the beginning of 2011 worn down by such pressure and to such an extent that the 2011 will represented her husband's wishes and not her own. He considered that it was likely her desire to avoid family squabbles and enjoy a peaceful life played a large part in her succumbing to those wishes rather than continuing to choose her own. In his judgment, taking all these factors together, Ivy had shown that even if her mother knew and approved of the provisions of the 2011 will, which he found that she did not, such approval was procured by the undue influence of her husband and/or her son. The judge went on to find that the transfer of the Southend property to her grandson was also procured by the undue influence of Mr. Chin and/or Winston. As a result, he held that the 2011 will was not valid and therefore admitted the 2009 will into probate. He also set aside the 2011 transfer. And then turning to the question of forgery. Testamentary instruments will be set aside where the will itself is forged, the will provisions are as a result of dishonest statements or actions, a person with a view to a gain for himself or herself suppresses or destroys a will, or a person advances a will that he or she knows to be false or invalid with a view to his or her gain. The burden of proof is on the party alleging the fraud, although fraud does not require any degree of coercion. Forgery of a whole will is very rare unless the will is very short. So the most common allegation of forgery is that the testator's signature has been forged. In the absence of an unlikely confession, it will be necessary to advance evidence from a handwriting expert. Such evidence is not, however, conclusive. Even if the expert determines that the signature is a conclusive forgery, recent decisions tend to suggest that the court will still pay greater regard to the evidence of those present at the time of execution of the will. If it can, however, be proved that the testator's signature has been forged, it's not necessary to identify the forger. It's up to the person alleging the forgery to satisfy the court that, on the balance of probabilities, the facts indicate that the testator did not sign the will. In order to do so, it will also be necessary for that person to overturn the court's presumption of due execution. If the court is satisfied that the testator did not sign the will, then the burden of proof will almost certainly then shift to the propounder of the will to prove due execution. In this regard, if the signature on the will is found to be a forgery, then the will would not comply with the statutory execution provisions. In order for a will to be valid, it must comply with the provisions of Section 9 of the Wills Act 1837. So to be a valid will, it must be in writing and signed by the testator or by some other person in his presence and by his direction. And it must appear that the testator intended by his signature to give effect to the will. And the signature must be made or acknowledged by the testator in the presence of 2 or more witnesses present at the same time. And each witness must either attest and sign the will or acknowledge his signature in the presence of the testator. So if a testator's signature is a forgery and the propounder cannot satisfy the statutory execution provisions, then the will be invalid. Suppression or destruction of a will tends to be at best a suspicion rather than an actuality. The difficulties of proof in these cases stem from the presumption that if the will cannot be found at the date of death, a testator has destroyed it himself. Such presumption could, of course, on the facts be rebutted, but this would not be without its difficulties. A false will is a will which the propounder knows is false or invalid. For example, where it is known that the will is not the deceased's last will. As with suppression, this may well be mere suspicion on behalf of its opponents. As a result of these difficulties, forgery cases are rarely successful and not many of them are brought. However, again, there has been a couple of recent cases, so let's take a look at them now. So firstly, Henderson v. Davies. Marsha Henderson married retired bus conductor turned lollipop man, Newton Davies, in 2004, when he was 76 and she was still in her 20s. When he died 9 years later, she sought to challenge his last will made in 2015, which only provided for her to receive £25,000 of his £600,000 estate, the balance of which Mr. Davies left to his only daughter, Paulette. Marsha claimed that she found another later will, executed in November 2011, in the attic of her home, stuffed into an empty Doritos crisp packet. She said she had no knowledge about how it came to be written or executed. The judge heard evidence that Mr. Davies did not eat Doritos, and this, coupled with the fact that it was very unlikely, given his age, he would have ventured into the attic for the purpose of storing his will, was compelling evidence against the validity of the will. In addition, opinion from a handwriting expert was that the signature displayed signs of hesitation and correction. However, the deciding feature was the fact that in evidence, Marsha kept referring to the will as her will rather than his will, as the judge considered would be the expected description. Taken as a whole, the judge found that the will was a forgery and further that it was a document created by Marsha. Accordingly, her claim to admit the second will into probate was dismissed. And then in Re Edwards in 2007, This was a case involving fraudulent calumny, something which I did not specifically mention, as it's in somewhat of a hybrid category, falling in part in undue influence and in part in forgery. Fraudulent calumny is where a false representation about the character of an individual is made to the testator for the purpose of inducing the testator to reduce or extinguish any benefit that individual would otherwise have received in the testator's will. Whilst there are similarities between undue influence and fraudulent calumny is not about the testator being threatened or unduly pressured into making his or her will in a particular way, but rather is the falsity of representations made which induces the testator to change their will. In order to prove fraudulent calumny, a claimant will need to show four things: that there has been a poisoning of the mind of the testator, and the person alleged to have poisoned the testator's mind must either know that the aspersions are false or not care whether they are true or false. Therefore, in circumstances where a person believes he is telling the truth about a potential beneficiary, even if what he tells the testator is untrue, the will would not be set aside on the grounds of fraudulent calumny alone. Thirdly, a claimant must show that he or she is a natural beneficiary of the estate. And lastly, that there is no other explanation for the disinheritance. In the Edwards case, Mrs. Edwards died on Christmas Day 2001. She had 3 sons, one of whom, Reggie, predeceased her. By her will made on 10 October 2001, Mrs. Edwards left the whole of her net estate to one of her 2 remaining sons, Terry. Her other surviving son, John, received nothing. Mrs. Edwards had made a previous will in 1990. Under that will, if her husband had predeceased her, which he did, then her estate was to be distributed equally between her 2 sons, John and Terry, save for a small gift to Lee, her only grandchild, who was John's son. What then caused the substantial difference between the 2 wills? John asserted that his mother changed her mind because of the undue influence exerted on her by Terry and by lies which he had told his mother about John and his wife. About 18 months before her death, and as a result of Reggie's untimely death, Mrs. Edwards went to live with John and his wife. She said she did not want to go back to the house. Terry was still living at home. He was drinking to excess and was verbally abusive towards his mother. And she told various people that she was frightened of him when he was drunk. The incident that led to Mrs. Edwards leaving the house was reported to the police, who were told by Mrs. Edwards that she wanted Terry to leave the house. When advised of his mother's wishes by the police, he refused to leave, saying now that Reggie was dead, the house belonged to him. Shortly after this, Mrs. Edwards was admitted to hospital for several weeks. Following her return home, she began to make allegations about John's wife, alleging that she had removed items and money from her house during her absence. Since these alleged events happened while she was in hospital, she can only have been repeating what someone else told her. It was during this period of time that she provided instructions to her solicitor as regards the execution of a new will. Having heard evidence from various witnesses, the judge said there was no doubt in his mind that Terry had every motive for persuading his mother to alter her will by any means. Did he take that opportunity? In the judge's view, he did. The judge said there was no other reasonable explanation for Mrs. Edwards having levelled such false accusations against John and his wife. He concluded that Terry deliberately poisoned his mother's mind by making deliberately untruthful accusations against John and his wife, and the effect of his doing so was to cause her own discretion and judgment to be overborne. As a result, the judge pronounced in favour of the earlier 1990 will. So that concludes this webinar on undue influence and forgery. Does anyone have Any questions? Suzanne, is there anything in the chat panel?
Hi Ellie. No, at the moment there's no questions or there's no chat there.
Okay, well, if anybody does have any questions that they think about afterwards, then please feel free to contact me directly. But for now, just conclude by saying thank you for listening, and to say I look forward to welcoming you at our next webinar, which is scheduled for the 30th of July, and when I will be considering rectification of wills, lost wills and deathbed gifts. So look out for more details about how to register for that shortly. In the meantime, once again, many thanks for listening. Thank you and good morning.